Good evening, everyone. Respected Dean Sir of School of Legal Jurisprudence Studies, Dr. Baswaraj Kubukadi Sir, respected resource person of the session, Honorable Shri Harekrishna Bhupathi Sir, former district and session judge, retired as a principal district judge from Rangareddy district, Hyderabad, respected faculty members of Department of Law, Central University of Karnataka, Dr. Anand Chinchure Sir and Dr. Renuka Gubewad Ma'am, respected trustee of Vignaneshwara Pratishthan Trust, Shri Mahadevaya Kardali, respected participants, teachers, legal professionals, research scholars, and students. I am Ragini Rajbhar, research scholar at Department of Law, Central University of Karnataka. On the behalf of Department of Law, Central University of Karnataka, and Vignaneshwara Pratishthan Trust, I welcome you all to the second day of 3-day webinar on new criminal laws. As you all know that Home Ministry recently announced the enactment of 3 laws: Bharatiya Nyaya Sanhita 2023, Bharatiya Nagarik Suraksha Sanhita 2023, Bharatiya Sakshya Adhiniyam 2023, which will be effective from 1st July 2024. We have gathered here to have an overview on the second procedural law, that is Bharatiya Nagarik Suraksha Sanhita. Our respected resource person will give a brief overview on this law to us. Now I invite Mr. Krishna Shekhar Sharma from Department of Law to introduce our today's resource person.
Good evening, one and all. Good evening, Honorable Shri Harekrishna Bhupathi sir. Good evening, Dr. Baswaraj M. Kubukadi sir, Dean, Department of Law, Central University of Karnataka. Namaste, Shri Mahadeva Karudalli sir, Trustee, Vignaneshwara Pratishtana Trust, and all other faculty members of Department of Law and the all esteemed participants. Myself, Krishna Shekhar Sharma, Research Scholar, Department of Law. It's my pleasure to introduce our esteemed resource person of the day. Shri C. Harekrishna Bhupathi sir pursued law from University College of Law, Andhra University during 1988 to 1986. He stood university first by securing first rank out of 570 candidates registered for Bachelor of Law examination held in January 1986 by Andhra University. He worked as judicial officer for 33 years in different cadre, including Principal District Judge Mahabubnagar, Rangareddy, and Khammam districts, and also Principal Special Judge Anti-Corruption Bureau, Hyderabad. He was also the Director of Telangana State Judicial Academy, Secunderabad for 2 terms. Along with he was awarded with Shri Kalagarla Subramanya Chaudhary Gold Medal, Shri Nuli Venkatachalapati Rao Memorial Prize for Law, Shri Vempati Ramabrahmam Memorial Prize, Diwan Bahudar D. Sri Rama Shastri Memorial Prize, Sri Jillala Tirumala Venkata Lakshmi Bayamma Garu Memorial Medal, Law College Decennial Celebrations Prize for securing highest marks in Bachelor of Law degree, Sri Durisetti Shashgiri Rao Prize for his achievements. With this brief introduction about our esteemed resource person, sir, I invite you to this session. Over to Ragini. Thank you.
Thank you, Krishna. Before moving on to the resource person, I would like to request our Dean Sir to give a brief welcome address to our resource person and the dear participants. Dr. Baswaraj Kubukadi Sir, I request you to give a brief note. Sir, there is little technical issues. I'll just connect Dean Sir's audio. Sir, you may unmute now, sir.
Yes. Good evening to all. It is an honor and a great pleasure for me to welcome all the participants to this August gathering. we have with us Honorable Shri Harekrishna Bhupathi sir, former district and session judge, state of Telangana, and sir also worked as a director for the Judicial Academy, both the state of Telangana and also Andhra Pradesh. He has a vast experience of 33 years in the judiciary. Definitely, it will enrich us. And the new law that has been enacted recently, the changes that were made would be brought to the notice of all the participants, and it will be very helpful for all of us. That is Bharatiya Nagarik Suraksha Sanhita. Sir will throw some lights on this legislation and discuss some of the key aspects, because it is very difficult to discuss all the aspects within 1 hour. So once again, with a pleasure and honor, I welcome you, sir, on behalf of the Department of Law, Central University of Karnataka, and on behalf of Vijnaneshwara Pratisthana, Marturu, Kalburgi, to this webinar, 3 days webinar. Welcome you, sir. And also I welcome all the respected participants. In this group, there are some judicial officers, there are some prosecutors, advocates, and also the academic fraternity and some law students. I welcome all of you to this second day of 3-day webinar on new criminal laws. And also I welcome the trustees of Vijnaneshwara Pratisthana Trust. I also welcome my colleagues and also the research scholars, students of my department. Lastly, I welcome all the participants to this webinar. Thank you.
Good evening to all. It is indeed a great pleasure for me to address this webinar on a very interesting topic. I'm very much thankful to Shri Basavaraj Garu, Dean, Department of Law, Central University, Karnataka, for giving this opportunity to me. Friends, law cannot be static. Law is bound to change. Law ever changes. Law adapts change, so as to cater to the needs of society from time to time, so as to tackle the emerging challenges, so as to overcome the lacunas and the latches in the procedural aspects, and to speed up and streamline the process for the expeditious disposal of the litigation. The change comes in through the amendments made to existing laws from time to time, and also by way of judicial precedents made by the constitutional courts. They were pointing out some of the lacunas or faults in the existing laws and suggesting ways, and also sometimes supplanting the existing provisions with new provisions, which we call as judgment law. And finally, by way of enactment of new laws in the place of existing laws, they were replacing the existing laws and repealing them. All these are needed to keep law abreast with the need of the hour. I would like to quote the torch-bearing observation of Justice V.R. Krishnaya, the legal luminary and the doyen of Indian judiciary, about the need of the change in law from time to time. In his famous judgment, Bengaluru Waterworks and Sewerage Board versus A. Rajappan and others, reported in 1978 to SEC, page 213. His Lordships observed, there are no absolutes in law since the life which it serves is relative. I repeat, there are no absolutes in law since the life which it serves is relative. We all know about his unique way and a classic way of presentation with figurative, ornamental, and metaphoric expression. This one way he further observed, esoterica is anathema per law. So what he underlined is that a law should always be flexible, feasible, and practicable. The present enactment, BNSS, which is the abbreviated form Bharatiya Nagarik Suraksha Sanhita 2013, is indeed an excellent law which is going to repeal the existing CRPC 1973 from 1st of July 2014 to 24 onwards. And it has got the far-reaching changes or reforms, which whatever name you call it, and also several beneficial and laudable changes. It has given a lot of importance to the technological changes. It has given much regard to the victim rights and also the rights of the accused. And furthermore, it has fixed the time limit for so many procedural aspects, right from the stage of investigation till the finality of judgment, and even for pronouncement of judgment, it has given a time frame. So all these reforms or changes are required to be dealt extensively, and strictly speaking, I require 5 or 6 hours to deal with the subject extensively. But I am conscious of the fact that there are time constraints today. However, I am asked to give a bird's eye view of the reforms, but the difficulty is that having worked as Director of Judicial Academy twice and having trained hundreds of judicial officers, the teacher within me doesn't satisfy unless I give the best out of me. So I have decided to deal with some chapters extensively by referring to each individual section and analyzing the same. And I have also further decided to go in a practical manner with a pragmatic outlook. Unlike the method chosen by some of the speakers of dealing the sections from first section to last section, I want to go in a pragmatic manner. So I will start with the registration of FIR, which is the first step that moves the criminal law into motion. Then let us analyze the further sections. Friends, I will straight away take away to chapter 13 of BNS, which corresponds to chapter 12 of CRPC. I'm making it clear at the threshold that I will be a little bit fast and quick in giving the presentation, because I'm anxious to cover more and more subject. At the same time, I request you to be quick enough to receive it, so that within the time constraints, we'll be covering a vast subject, and I may detain you for a few more minutes than the scheduled time, but not too long. First of all, let us go to chapter 13 of BNSS, which corresponds to chapter 12 of CRPC, which speaks about the investigation by police. CRPC chapter 12 consists of sections 154 to 176, and the new sections in BNSS are from section 173 to 196. Let us go to those sections first. Share it.
Sir, you are on mute, sir. Please unmute, sir.
You know, this is the difficulty with the webinars, madam. Am I now audible? Am I visible now?
Yes, sir. Yes, sir. Screen is visible. You are audible.
Thank you. Section 154 of CRPC, all of us know that it consists of 3 clauses. Now, under section 173 of BNSS, there are 4 clauses. Class 3 of 154 has now become class 4 of section 173. In between class 2 and class 4, very important class, that is class 3 is introduced. Now let us deal with these classes one after another. What are the changes brought into these classes? In class 1, the new change brought into is with regard to these words. Irrespective of the area where the offense is committed, may be given orally or by electronic communication. Class 1 speaks about the report given to police in respect of cardinal offenses. And now the rider is added that irrespective of the area where the offense is committed, that is 0 FIR. Now the police should not insist on jurisdiction. They should receive the report, and then we should proceed with the registration of the FIR in cardinal offenses. Then what is open to them, we all know. After registration of FIR, they can transfer it to other police station having proper jurisdiction for investigation. So they cannot deny the receipt of FIR. Then the other thing added in the second clause is this: FIR can also be lodged through electronic communication. There are definitions for electronic communication and bail bond, all these things in section 2 that I will go at a later time. Now, this speaks about the other option open to the informant to lodge a report through electronic media, electronic communication. What is electronic communication? That is defined there under section 2. But electronic communication doesn't contain the signature. Then what should the informant do? Informant or the victim, whoever he may be, he should do. The time is given for 3 days to sign on the report. That is a change brought into in 173, clauses 1 and clauses 2. Clause 1 and 2. Then coming to clause 3, this is very, very important. What it speaks about is that suppose the report is given about a cardinal offense which is punishable for a sentence of more than 3 years and less than 7 years. See friends, the limit is more than 3 years and less than 7 years. Then the SHO need not immediately proceed with investigation of registration of FIR, has got everything space. What he should do with the permission of the DSP, he can make some preliminary investigation. He can do some preliminary investigation within 14 days. This is, of course, in accordance with the judgment of the Supreme Court in Lalit Kumari versus State of Uttar Pradesh, 2014 to SCC page 1. Certain directions are given by the Supreme Court there, certain observations were made, and it is in line with that judgment. So now we have to deal with 173.3, and we have to see 173.3 along with 176.3. That will go in a little shorter now. 173.3 speaks about the procedure to be adopted in case of the offence which is punishable with imprisonment more than 3 years and but less than 7 years. For which it is stated that the SHO need not immediately proceed with investigation, but with the permission obtained from the DSP, he can make a preliminary investigation. That should be done within 14 days. This is the important change brought in 173.3. Then coming to 173.4, what is 173.4? This with same, that is 173, 154.3. 154.3 has now become 173.4. We all know the procedure open when the police fail to receive the report or fail to register the FIR. Then what is the course open? That is stated in 154.3. It speaks that in such a case, the informant can send the report to the higher official, higher cadre of the police, that is to the superintendent of police, or some other higher cadre than this SHO by registered post. Now, that is further elongated. Section 4 is now further elongated with a clause. Here, of course, this clause B doesn't appear. If you read 173.4, you don't find clause B. But of course, when we deal with 175, there appears clause B. But of course, we can understand now that it can be divided into 2 clauses. The first clause is about the course open to the informant in case his report is not received by the SHO and FIR is not registered. Then what he should do, he should send the report by registered post to the superintendent of police or any higher police official. Now, a further clause is added there that failing which he may make an application under subsection 3 of section 175 to the magistrate. 175.3 speaks about the same. We'll go to that shortly. Now, we all know, suppose the police fail to take the report and then fail to act upon it, what is the course open to the informant or the victim? The victim can file a complaint before the magistrate having proper jurisdiction. Then the magistrate can direct the police to register the FIR. That we know. That is the procedure under 156.3. Filing complaint under 200. Now there is section 223 of BNSS. So what it speaks about, this clause speaks about the other course that in case even after the recourse is avoided by the informant by sending the report to the superintendent of police, and even then no action is taken with the superintendent of police or other police official, then the other recourse open to the informant is to make an application under subsection 3 of section 175 to the magistrate. So these are the changes brought in 173, first section. Then going to other section, we have to compare 176.3. That I will explain shortly. As I already said, class 4 now is class 3 under 154. 155 of CRPC that speaks about report given in respect of non-cognitive offences. Now it is 174 under BNSS. What is added herein is this clause. Section 1, subsection 2 is now added with this clause, that is, forward the daily diary report of all such cases fortnightly to the magistrate. So now it is for the SHO to forward the daily diary report of all such cases. Which cases? That means cases which are non-cognizable, to the magistrate every fortnightly. So it is incumbent upon him. He is now obliged to send such a report to the magistrate for every change brought into in section 174. Then 175, just now I explained. (156) is now old 156 has now become 175. The first class, in the first class, this is added. Provided that, considering the nature and gravity of the offence, the superintendent of police may either himself investigate or require the deputy superintendent of police to investigate the offence. That means delegation of power by the superintendent to the DSP to investigate the offence, which is punishable, which is a cognizable offence. Next, just now I said 173, just now we dealt with 173.4. Now we have to see this 175. What is the course open to the informant in case his report is not received by the SHO? Just now I said, then he can send the report by registered post to the higher police official, and even if such a report is not received by the higher police official and no action is taken by him, then the other recourse open to him is to move an application before the magistrate. Now, this speaks about the same. The magistrate, upon considering such application made under class B, here of course class B appears, of subsection 4 of section 173, and the submission made in this regard by the police officer after such an investigation as above mentioned. See friends, here the police officer is also given an opportunity to explain, which he previously didn't have. Police officer had no voice at all under CRPC to submit at the time when the court was referring a complaint to the police for investigation. Here, now, such an opportunity is given to the policeman to explain, to make his own submissions. That is the change brought into. Then, other important change, that is class 4. Suppose a complaint is filed before the magistrate against a public servant. Then, the magistrate should not immediately act upon it. Then what is required to be done is, you should call for a report from the superior officer of that public servant. And then upon consideration of that report, as well as, what is as well as? The submission made by the public servant as to the situation that led to the incident. Assertions made by the public servant as to the situation that led to the incident. Then the magistrate will act upon it. That means two things. First thing is, if a complaint is filed against a public servant with the magistrate, then the magistrate should not immediately act upon it. What you should do is, you should call for a report from the superior officer of that public servant. And upon consideration of the report, as well as the assertions made by this public servant about the situation that led to the incident, so alleged, then the magistrate has to act upon it. Then you may ask as to, is anywhere stated herein about the method of knowing the assertions made by this public servant? Should he be called? This clause is silent. But it's nothing but common sense. That what happens normally when a report is called from the superior officer, he may give a charge memo to this public servant. Public servant may in turn submit his explanation to the superior officer. Superior officer, while sending the report, may also enclose this this assertion made by the public servant. So that gives an opportunity to the court to consider all these things. So this is the protection given to public servant. Then, friends, we have to correspondingly see section 223 2 also. That is a complaint. Now, section 200 of CRPC has become now 223. There, the same procedure is stated there. How to deal with a complaint filed against a public servant. There it is stated, the same procedure. I will go to that in the line. Then section 157 of CRPC, now section 176 of BNSS. Here, of course, this is a very important clause added. Under clause 2, the same clause which is embodied in that particular clause under 157 is continued now. That is in respect of recording the statement of victim in a rape case, and it is further added here. This is to safeguard the interests of the victim. Provided also that statement made under this subsection may also be recorded through any audio, video, electronic means, preferably cell phone. So utilization of the technological developments. Next, class 3 is now added. We have to see, we have to compare same clause under 173 with the clause under 176. Just now I said 173 class 3, what does it speak about? It speaks about the offense which is punishable for imprisonment for more than 3 years and less than 7 years. What is required to be done therein? The SHO can proceed with the preliminary investigation with the permission of the DSP within 14 days, and then he can proceed further. Now, this is about the offenses for which the punishment is more than 7 years. What does this class speak about? On receipt of every information relating to commission of offense which is made punishable for 7 years or more, the officer in charge of the police station shall, from such date as may be notified within the period of 5 years by the state government in this regard, cause the forensic expert to visit the crime scene to collect the forensic evidence in the offense, and also cause videography of the process on mobile phone or any other electronic device. That means what is required is that the SHO should proceed with the process of collection of forensic evidence. It is further added, suppose in some states forensic labs are available, forensic experts are there, but in other states such a facility may not be there. For other states, what they should do, they can borrow the same from the neighboring states. That is further added here. Provided that where forensic facility is not available in respect of any such offense, the state government shall, until the facility in respect of that matter is developed or made in the state, notify the utilization of such facility of any other state. That means any other state or neighboring state, the facility can be availed. So this is very, very important change brought into. So we have to compare 173 with 176.3. Then 177, previously it was 158, the same thing. Then 178, 159 previously. Then coming to 179, which corresponds to 160 of CRPC. That means police officers' power to require attendance of witnesses. Here some laxity, some benefit, or some convenience is given to some informed witnesses. That means if a witness is a woman or a person of below 50 years age, or a senior citizen or 60 years age, or more than that, and an informed person, then what's open is, so that the statement of such a witness can be recorded at any convenient place of that witness, or if that witness is willing to come to the police station, then he can as well be asked to come to the police station where his statement can be recorded. 180 and 181 They correspond with 160 and 160, 161 and 162 of CRPC. 161 statements and 162, the use of such statements. Same thing continued now. How to record 161 statement? How the statements should be used for recording contradictions and omissions? The same thing stated here. Then 163 has now become 182. Coming to 183, 183 corresponds with 164 of CRPC. Here, clause 1, it starts with the words, any judicial magistrate of the district in which the information about commission of any offence has been registered may record any confession of statement made to him in the course of investigation. Then, in class 6, with a rider added, in class 6A, recording of statement of rape victim, provided that such statement shall, as far as practicable, be recorded by a woman judicial magistrate and in her absence by a male judicial magistrate in the presence of a woman rape victim. In case of rape victim, suppose if the availability of woman judicial officer, then that should be recorded by woman judicial magistrate. As far as practicable, provided that in cases relating to offences punished with imprisonment for 10 years or more, or imprisonment for life, or with death, the judicial magistrate shall record the statement of the witnesses brought before him by the police officer. So 164 statements now under 183 of BNSS. The class 6 has now previously has now become class 7. Then 164 of CRPC has now become 184. Here, of course, a duty is cast upon the medical officers to send the report within 7 days to the investigating officer. So now a medical officer shall, within a period of 7 days, forward the report to the investigating officer, who shall forward to the magistrate referred to in section 193 as part of the documents referred to in class A of subsection C of the section. That means the medical officer should immediately, within 7 days, send the report to the SHO, and SHO in turn shall send the same to the magistrate. Then search by police officer, 185. Here also, the utilization of technological developments, audio, video, electronic means. Search conducted under this section shall be recorded through audio, video, electronic means, preferably by mobile phone. Every police officer has got that facility now. Then he has to record it through this means. Then 186. Previously, that is 166. 167. Far-reaching changes are brought into now. 167, you all know about the remand. Now, the changes brought into this section are very much useful to the investigating agency. All of you know that previously, police can seek police custody only in the initial 15 days period, and they cannot ask for police custody after once that period has elapsed. Now, what is the change brought in? This is in class 2. The following are added. After taking into consideration the status of the accused person as to whether he is not released on bail or his bail has not been cancelled. Why I am reading this is, it has got some importance. I will explain shortly. That means now the police can seek police custody of an accused. Need not be within the first 15 days period, initial 15 days period. But the total custody should not exceed 15 days period. It should be understood in such a way. Total police custody period should not exceed 15 days. But this police custody can be sought in case of the offences for which the investigation should be completed within 90 days. The police custody can be sought within 60 days. And in case of the offences for which the investigation should be completed within 60 days, the police custody can be sought within the period of 40 days. But the whole period should not exceed 15 days. It can be asked in parts or in whole. Friends, let us read this important.
Sir, the video has hanged, sir. Audio also.
Sir, voice is
Sir
not
will
audible.
collect in a while. Actually, electricity has gone at his side. He will join again.
मग कशी तो
Sir, your voice not clear.
Sir will join soon. There is some Wi-Fi issue at his end. He will join again. I have just contacted him.
Okay, ma'am, no problem.
hello Ragini ma'am.
Okay, ma'am.
Hello.
Ma'am, after the session, you can send the PDF. Hello.
Ragini ma'am. Hello. Hello. Hello.
Sir, the resource person will join again. Just please wait for some time.
Ragini madam,
Yes, sir.
can you please share that video because we are unable to following up because continuation is a problem. Could you please share it after the end of the session, please?
Share what, sir?
Yeah, sharing of the information of PDF format.
Or document. We will request sir, Honorable sir,
Okay.
to share it with us.
Yeah. Because
Yes.
interruption happened, na? Could it able to
He
follow
will
it?
join again, sir. Some electricity issue happened. So because of
No
that,
issues,
Wi-Fi
no.
has got disconnected.
Yeah, no issues, no issues. Thank
Yes,
you
sir.
very much.
Do we have yesterday's sessions recording, madam?
Yes, sir. We have shared in the WhatsApp group.
Okay, I didn't receive it. Okay, thank you.
Okay, sir.
Yeah, I got it. It
Am I
is
visible?
available. It's in the
Am I-
website. You can kindly see, gentlemen.
Am I visible now?
Yes, sir. You're visible now and audible also.
Sorry for the disruption. I couldn't find because there is some disruption in Wi-Fi.
No
Now
problem, sir.
I reconnected. I will explain this section once again now. So
Sure, sir.
187
Thank you,
is a
sir.
very important section now because it corresponds to the previous section of 167 of CRPC. 167, it speaks about the remand. Suppose the investigation is not completed within 15 days, what should be done? That is explained under 167. We all know. Here, some important changes are brought into. Now, the availability of the investigating agency is to seek police custody even after 15 days of initial period. So we all know that police custody should be sought only during the first 15 days initial period. Thereafter, police cannot seek police custody. Thereafter, the other period will be judicial custody only. Now, under this class 2, introduced in 187, the police can seek police custody even after the expiry of first 15 days, but within 40 days for an offense for which investigation should be completed within 60 days, or within 60 days for an offense for which investigation should be completed within 90 days. But what are the other requirements laid down here? Read these clauses very, very carefully. This clause speaks about the police custody in this way. In class 2, the following are added. After taking into consideration the status of the accused person as to whether he is not released on bail or his bail has not been cancelled. First thing, two things. Suppose the accused is released on bail, he will not be in the police custody. He will not be in the custody. Either it is judicial custody or police custody. If once he is released on bail, then if he is released on bail, then in case his bail is cancelled, the prosecution or the investigating agency may move an application seeking the cancellation of the bail. And in case the application is allowed, then he will be taken back into the judicial custody. Then he will be in the judicial custody. So under those circumstances, the court may authorize the detention of the accused in such custody as the best for a term not exceeding 15 days in the whole or in parts. That means the total period of police custody should not be more than 15 days. It can be within the period of 15 days. It can be for a whole period of 15 days or in parts for a total period of 15 days, but should not exceed 15 days. But this facility is given to the investigating agency to seek police custody within 40 days and within 60 days of the respective offences for which investigation should be completed within 60 days and 90 days respectively. And what are the other clauses? That means this man should be in the judicial custody only. At the same time, you have to read the corresponding provision under section 480 CRPC. Section 480 speaks about the bails. There it is stated that simply because the investigating agency can seek police custody and such an option is given to investigating agency under this section, that is section 187, that should not be a ground to reject the bail. other conditions can be taken into consideration. The holistic approach to be taken by the court. That is stated under 180. So we have to read, friends, 180 also simultaneously along with 187. Then the further rider is added in explanation 2. What is this? Nowadays, what is happening is the police are taking the accused into custody, are keeping the accused somewhere other than police stations. That is discouraged now. So it is insisted that the accused should necessarily be kept in the police station or in proper custody, which is recognized herein. That is provided further that no person shall be detained otherwise than in police station, under police custody, or in prison under judicial custody, or place declared as prison by the central government or state. But only in these places only the accused should be kept. So these are very, very important, far-reaching changes brought in. Of course, the other classes just now they are enlarged like this. Class 2A has become class 3, and class 2B now to class 4. All these things you can see. Then report of investigation by subordinate officer. That is 188 now. The release of accused when evidence deficient, 189. Cases to be sent to magistrate if evidence is sufficient. This is important. Provided that this is what is added now under 190. Provided that if the accused is not in custody, the police officer shall take security from such person for his appearance before the judicial magistrate, and the judicial magistrate to whom such report is forwarded shall not refuse to accept the same on the ground that the accused is not taken into judicial custody. You have to see this judgments of the Supreme Court. Siddhartha for the state of UP, that is one judgment of 2021, you can see. Then section 191, then 192, diary of proceedings in investigation, section 193. Then 193, that means final report or charge sheet, whichever name you call it. So these are the changes brought into 193, filing of the final report after the conclusion of investigation. So what is stated herein, suppose previously under 173, there is a requirement that in case of the offenses of rape of child, that should be completed within 3 months. Now it is added that such investigation should be completed within 2 months, and furthermore added that such investigations in respect of the POCSO offenses. POCSO offenses, the victims are victims. For them, of course, the investigation should be completed within 2 months. Then other important thing is electronic communication. That means the police officer shall, within a period of 90 days, inform the progress of the investigation by means of electronic communication to the informant or the victim. It is the duty of the police officer duty bound now to inform to the victim or the informant about the progress of the investigation within 90 days by means of this electronic communication. Other important thing is about the further investigation. And before that, the supplying of copies and sufficient number of accused. This supplying of copies can now be done through this electronic mode. The supply of copies to as number of accused as they can be furnished the copies through electronic mode. And then coming to further investigation. The further investigation, you all know, under section 173A of CRPC. Now this is under clause 9 of section 193. There it is stated that further investigation should be completed within a period of 90 days. Then the upper limit is not fixed. So you have to see this. This should be completed within 90 days. Suppose the police want to proceed with further investigation. Suppose in a particular case where the police will plead that a particular accused who is at large is now apprehended, then investigation should proceed against him, and charge sheet has to be filed in respect of the further investigation. That can be done, or someone investigates more material has to be collected. That can be done within the period of 90 days. But further extension should be done by the court. But upper limit is not given. That means it should be construed, it should be understood that it should be within a reasonable time. Then 174 has now become 194. 175, that means summoning of the persons in connection with the investigation under 174. That is 194 now. Here, some facility is given to the informed witnesses. A male person under the age of 15 years or above the age of 60 years, or women, or mentally or physically disabled person, or a person with acute illness. Such people need not attend to the police station, and their convenient places can be visited by the police for the purpose of recording the statements of these witnesses. That is included herein. Coming to the other important chapter, that is chapter 16 of BNSS, which corresponds to chapter 15, examination of a complainant. Here, one important change brought into is that of providing an opportunity to the accused to be heard. Previously, that was not there. In fact, there are judgments, reported judgments, which say that the accused has no voice at all till he is summoned through the process of the court. When does it arise? The court may issue process under 204 CRPC. Then only the appearance of the accused before the court, and then the accused will have a voice to speak. And prior to that, he cannot interfere. But now this change is brought into, it says that the accused can also be given an opportunity to be heard before the cognizance of offense is taken under 223 on a private complaint. That is the trend is to discourage some false private complaints. Then against the public servant, already explained it. Suppose the complaint is the public servant, then once the court's open, the court should call for a report from a superior officer of the public servant, and that should be considered, and also the assertions made by the public servant should also be taken into consideration, and then the court can proceed further. So what is required is the sanction. You all know the sanction against the public servant, the sanction to proceed with, that is now under Section 217. Previously that was under 195. Special summons in petty cases. Now it is under 229. The upper limit is increased up to 5,000. Then commencement of proceedings before magistrate. This is now chapter 17. Now, supplying of copies, previously that is under 207, 208, now under 230 and 231, supplying of copies can be done through electronic means. Then committal, the time frame is fixed now. You know, in cases, in some of the courts, at magistrate courts, there are inordinate delays. Even for committal, they are taking too much of time. They are not committing the cases to the sessions courts under 209 immediately. That should be discouraged now. Now a time limit is fixed now. That means committal should be completed within 90 days. And that can be mostly extended up to 180 days. Discharge applications are delaying the process. You know, sessions cases, what is happening now? One discharge application disposed of, immediately another discharge application is filed. If there are so many accused, each one of them is taking his own time. So that should be discouraged now. So a time frame is fixed. Under 250, the application seeking discharge should be filed by an accused within 60 days from the date of committal. So this is the time limit fixed now. Then when to frame charge for framing charges also, the courts are taking much time now. So that should be discouraged. So that is discouraged practically by introducing this provision. That is under 251. That means charge should be framed within 60 days of first hearing on charge. Then evidence, prosecution evidence. Again, the utilization of the technology. Evidence of a witness under this subsection may be recorded by audio, video, electronic means. 530 also speaks about this. 530 is the final section. 531 sections now. 530 is the end. That also speaks about recording of evidences through audio, video, electronic means that I will show you shortly. Then what does it speak about? This section says, 254 says that the evidence can be recorded through audio, video, electronic means. The audio, video trial. The deposition of evidence of any police officer or public servant may be taken through audio, video, electronic means. That means maximum utilization of the technical developments, technology. Then warrant procedure case, that is chapter 20. Of course, you know, there are two kinds. That is warrant procedure case instituted upon a police report or other than police report. Two different procedures. The first procedure is in respect of a case instituted upon a police report. Section 262. Here also, a time frame is fixed for filing discharge petition. Accused should file a discharge petition strictly within 60 days from the date of supplying of copies. Supplying of copies on 230. That means from the date discharge petition should be filed within 60 days only. That is the time limit fixed. And here also the charge should be framed within 60 days from the date of first hearing of the charge. Then another important change is brought in. That is, suppose if the warrant procedure case issued other than police report. That other than police report means upon a complaint. Then the procedure, you know, the procedure is that first of all, before framing of charges, the complainant has to adduce evidence and his witnesses may be examined, and after framing of charges, they may be again recalled and they will be further examined and they will be cross-examined by the accused. After that means before framing of charge and after framing of charge, 2 times examination. Here, of course, this is added now. What is this here? Suppose a witness examined before framing of charge, he could not be produced, despite giving sufficient opportunity. Some reasonable opportunity was given, and despite that, the witness was not produced. Then why is the course open? Should be prolonged somewhere? Should be prolonged further? Should be elongated? No, this should be discouraged. For that, class 7 is added now, where despite giving the opportunity to the prosecution and after taking all reasonable measures under this Samhita, if the attendance of the prosecution witnesses under subsection 5 and 6 cannot be secured for cross-examination, it shall be deemed that such witness has not been examined for not being available, and the magistrate may close the prosecution evidence, reasons to be recorded in writing, and proceed with the case on the basis of materials on record. That means the witness who was examined prior to the framing of charge was not produced by the complainant, and despite giving sufficient opportunity, the witness is not secured and there is no convincing reason put forth, then the course open to is to treat as if the witness is not examined. So this will pave the way for quick disposal of cases. It's summons procedure cases. Examination of here, see friends, a change is brought into. How this is brought into, we have to wait and see how this will be appreciated. Here, we all know that in summons procedure cases, there is nothing like discharge of an accused, because there is no question of framing of a charge. But what happened in some reported judgments, you may be knowing Arvind Kejriwal's judgment, Kejriwal versus Amit Sibal's case. At the Delhi High Court discharged the accused under Section 251. And they have placed reliance upon the previous judgment of the Supreme Court, that is Bhushan Kumar versus State, NCT of Delhi, 2012, 5 SCC page 424. There also, of course, the discharge was invoked. And of course, subsequently, in Amit Sibal versus Arvind Kejriwal and others, 2018, 12 SCC 165, the Supreme Court clarified that there is no discharge so far as summons cases are concerned. Now, of course, it is added under Section 274 that provided that if the magistrate considers the accusations as groundless, he shall, after recording the reasons in writing, release the accused, and such release shall have the effect of discharge. That means release in the form of a discharge. That is the important change brought into. Then coming to Section 283, power to try summarily. These upper limits are more and more offences are included here. The upper limits are increased now. The value of the properties previously 2,000 rupees, now 20,000 rupees, and also the same way you can read them. Because of the time constraints, I'm skipping them. Then coming to plea bargaining. Then here the time limit fixed for working out within 60 days, first to sit to work. That means here, if the court is satisfied that the application has not been filed by the accused voluntarily, it shall provide time not exceeding 60 days to the public prosecutor or the complainant of the case and the accused is to work out a mutually satisfactory disposition. This is important, and further, of course, the time limit is fixed now. Then a further trend, encouraging trend, because plea bargaining is not frequently resorted to in the courts now, which we are finding now. But there is a judgment of the Supreme Court. Here, of course, you may be knowing in the inhuman conditions in 1382 versus pronounced on 5th of February 2016. There, of course, the Supreme Court expressed the view that plea bargaining should be encouraged. Further, of course, now there are some provisions introduced. Suppose if the accused is the first offender, then the 1/6 of the punishment. Suppose if the accused, in case of suppose minimum punishment is prescribed, then previously that was not encouraging. Now it is changed into one fourth of the minimum punishment. So these are all the trends to encourage plea bargaining. Now let us come to the other two chapters, that is chapter 2 and chapter 3. Chapter 2 speaks about the constitution of the courts. Chapter 3 speaks about the powers of the court. These are very, very important. So chapters 2 and 3 of CRPC corresponding to the same chapters under BNSS. Here, for your convenience, the deletions are shown in red color and the additions are shown in blue color. Here, the important change is that now hereafter, after the advent of BNSS, metropolitan setup is taken out. Metropolitan setup will not be after the advent of the BNS, after implementation of BNSS. And then the assistant session judge will not be. Assistant session judge is not there in BNSS. And so also the metropolitan setup is totally taken out. So for that, of course, there are exclusion of sections under section 8, section 10, section 16, section 17, section 18, and section 19 are excluded. Then what are the sections under CRPC? Section 8 to section 25A, now under BNSS, section 6 to section 20. So these are the sections they are omitted now. Metropolitan areas, subordination of assistant session judge, courts of metropolitan magistrate, chief metropolitan magistrate, additional chief metropolitan magistrate, chief metropolitan magistrates, subordination of metropolitan magistrates. Out of 21 sections in chapter 2 of CRPC, from section 6 to section 25A, the above 6 sections are omitted, and now the count tallied for 15 sections in chapter 2 of BNSS, that is from section 6 to section 20. Friends, the existing provisions of chapter 2 of CRPC are as follows. Here, of course, this metropolitan magistrate is removed. Other courts continued, but except this, the section goes on. This red marked portion is removed now. Then coming to section 7, territorial divisions. Here, this portion is removed, provided that every metropolitan area shall, for the set purpose, be a separate division, subdivision, that is removed. Then section 8 is totally removed. Metropolitan areas totally removed. Section 9, now this is section 8 in BNS, because once section 8 is removed, then now it has become, section 9 has now become section 8 in BNSS. And in BNSS, these are further added. Section 7, session judge may from time to time make orders consistent with the Sanhita as to the distribution of bills among the additional session judges. Section 8 is added, or clause 8 is added, clause 7 and 8 are added. Then section 10 is taken out, subordination of assistant session judge. As I already said, metropolitan setup is taken out, so also assistant session judge, the post is taken out. Then section 9, previously section 11 of CRPC. Then section 10, how section 10 is now, I will show. Now 13 has become section 11 now. This is taken out from the section, existing section. The High Court may empower a special judicial magistrate to exercise the power, that is taken out, metropolitan magistrate powers. Then 14 has become section 12, and these are taken out. Metropolitan area, this metropolitan area and metropolitan magistrate comes. Then section 15, 13 of BNSS, 16 is totally taken out, 17 is taken out, 18 taken out, and 19 is taken out. And 14, this has become now section 20, previous section 20 has become now 14. And section 21 has now become section 15. Section 22 has now become 16. 23, 17. 19, this is 20, last section is 20. The BNSS, now 25A has become 20. Now, friends, coming to the new sections in BNSS. Section 20, the following are added. Public prosecutor, director of prosecutions. And here, of course, the important change is that in district level also, some deputy director of prosecutions can act as a district prosecutor, director of prosecutor. Next, coming to the powers of courts, straight away we shall go to section 23 of this 27. Old section 27 is removed. These are the old sections. Then we will come to new sections. 23, the powers of the magistrate are increased. Previously, he can impose fine up to 10,000 rupees only. Now he can impose fine up to 50,000 rupees. 3 years, he can impose sentence up to 3 years, and fine now he can impose up to 50,000 rupees. And second class magistrate, previously his power was to impose fine up to 10,000 rupees or 5,000 rupees only. Now it has become to 10,000 rupees. Then they can also impose community service. They can also ask the accused to undergo this punishment also. There is community service. What is community service? To do community service, that is explained herein. And also fine, the judicial first class magistrate's power is now to impose sentence up to 3 years and also fine up to 50,000 rupees. And both are of community service. You can also impose the punishment of directing the accused to do community service. What is community service? The name itself speaks about the same, doing some service to the community, but it's also further added here in that it doesn't entitle him to claim any remuneration. Then, friends, because of the paucity of time, I will straight away take you to some of the important changes. Let us see them quickly. These are the definitions introduced in BNSS. Audio, video, electronic. What is that? It is explained here. Then electronic communication definition is given. Then bail. Previously, no definition was given for bail. Now, bail bond and bond. What is the difference between bail bond and bond? Normally, of course, the magistrates are writing now order like this: accused shall be enlarged on bail or is executing a bond for such and such. Now, with bond with sureties. Now they should specifically mention here. Bail bond means sureties, with sureties. Bond means without sureties. The difference is drawn. Bail bond and bond. Next, this community service explanation. Then the investigation. The word investigation is further elongated with an explanation given herein. Explanation has been added to the definition of investigation to clarify that in case any provisions of the Special Act inconsistent with the provisions of BNSS, the provisions of Special Act shall provide. Then, other important thing is the definition of victim. Victim definition. What victim definition already existed there? If you know, victim definition under section 2 WA. Now under section 2(1)Y. What is the difference between these two? These things shown in blue color were taken out. That means accused need not be charged now. So this modification of elimination of the requirement of the accused person being charged explains the process of victims receiving compensation in some cases where they are entitled to receive compensations. Then the proof of documents for public servants, that is IOs, doctors, experts, etc., their non-availability due to transfer, retirement, death, etc., avoidance of delay in the progress of trial. Section 336 is a wonderful section brought into to overcome these difficulties, where it is mentioned herein that in case a IO or an expert or a doctor, he cannot be found, or without delay he cannot be secured, or he is retired from service and he cannot be secured without much delay, then what's open is his successor can be examined, or who is holding the post can also be examined with regard to the evidence concerning to a particular document. Then witness protection, 398. This is a laudable change. Hitherto, of course, witness protection is neglected. Now there is underlined, and if the state government shall prepare and notify a witness protection scheme for the state, and much emphasis is laid down now. Then withdrawal from the prosecution. There are several judgments of the Supreme Court from time to time about the rights of the victims. Here, of course, what is stated is, the state may seek the withdrawal from the prosecution in a particular case. Here, what is insisted is that victim should also be heard. 360 has laid down the condition that victim should also be heard while considering such an application. It's a wonderful change brought into. Then jurisdiction in respect of the maintenance sought by the parents, the neglected parents. Previously, of course, there is 125. Now it has become 144. Now it is laid down 145. It is included 145. Here it is stated that the jurisdiction is also for the place where the neglected parent resides, either his father or mother, where he resides. That also is invested with the jurisdiction. Then avoidance of delays. See, friends, what a wonderful change brought into judgment. But judgment also, a time limit is fixed. Under Section 392 BNSS, a judgment should be pronounced by the court immediately after the termination of the trial or at some subsequent time, not later than 45 days, of which notice shall be given the parties or their advocates. For session judgment, within 30 days only, but that period can be further extended up to 45 days. That is stated in Section 258. For judgment to be pronounced by Sessions Court, the judgment should be pronounced immediately or within 30 days from the date of the conclusion of arguments, which can be extended for a period of 45 days for reasons to be recorded. So the reasons should be recorded. That is also there. It's incumbent upon the court to record the reasons for the delay. Uploading judgments. For uploading judgments, the time is 7 days only of the pronouncement of the judgment. That is on 392. Of course, the metropolitan setup is taken out. Therefore, 355 is removed now. The difference between 354 judgment, 355 judgment. Metropolitan judgments and 355. Now that is taken out. Then judgment and production of accused in custody. Suppose the accused could not be produced on the day fixed for the judgment. Then its production can be through audio, video, electronic means. That is on 392. Friends, some more wonderful changes. What are they? The voluntary absence of the accused after once the trial has commenced. That is seriously frowned. That means an accused may adopt delaying tactics. He may try to cause some delay in the progress of this trial. He may practically play with the court. Such tricks played with the accused can be tackled now seriously. That's seriously frowned in BNSS. So BNSS facilitates the pronouncement of judgment in absentia of accused in case of a proclaimed offender. The same are incorporated in 356 BNSS. In 356, what does it speak about? This is 356. Inquiry, a trial of judgment in absentia of proclaimed offender. See, friends, the red marked portions, you have to concentrate them. It deems to operate a waiver of the right of such person to be present and tried. Who is the person? When a person declares a proclaimed offender, whether or not charged jointly and absconded and evaded the trial, there is no immediate prospect of his arresting, then this procedure can be invoked. The court shall not commence the trial unless a period of 90 days elapsed from the date of framing of charges. That is, the court should wait for 90 days from the date of framing of charges. The court shall ensure that the following procedure has been complied. This is the procedure. 1, 2, 3, 4. These are conditions laid down there. Then, provided that no appeal against the conviction shall lie after the expiry of 3 years from the date of the judgment. The new code has also enabled the court to proceed with the trial in absentia of accused on 355 in case the accused continuously causes disturbance. You may be knowing some accused continuously causing disturbance to the court proceedings. How to tackle it? Because the law, because there are mandatory provisions in the code that evidence should be recorded only in the presence of the accused and the trial should be proceeded in the presence of the accused only. Now, how to tackle such a people? That is stated in 355. The court can record reasons, and even in the absence of the accused, the court can proceed. That is stated in 355. Then coming to mercy petitions, 472, at every level, at which stage, time fixed. The duty is cast upon the jail superintendent to inform to the accused about
Sir, excuse me, sir. Your screen is not visible, sir.
Screen is not visible.
Yes.
Is it did it happen just now, or is it continuing for long?
No, sir, just no.
Just a fraction of seconds.
Screen is not visible. Is it
So you were sharing a document. That document is now not visible.
document not visible? Permission to share document is rejected now, madam. You have to give the permission. That is
Okay, sir.
from your side.
So you may do it now, sir.
Okay, thank you so much. It's already covered. It's already covered. Is it visible now?
Yes, sir. Yes, sir.
Yes, sir.
Yes, sir. Yes,
Then,
sir.
could you able to follow till 355 and 356?
Yes, sir. You were talking about mercy petition. Yes, sir.
Mercy petition. That is 472. 472, every clause is important. Even for the government, the time limit is fixed for sending the remarks on a mercy application submitted by an accused. So this is very important change brought into 472. So these are all the red marked portions are all the changes brought into. Arrest of accused. Let us cover this arrest of accused. For offense punishable with sentence more than 3 years and less than 7 years, what should be done? Preliminary investigation should be done. For offense more than 7 years, punishable with imprisonment more than 7 years, forensic evidence should be collected. But here, for an offense for which the sentence is not more than 3 years, then such accused should not be arrested without the permission of the DSP. Or informed, if a person is informed, are below, are about 60 years of age. Next, under CRPC, there is a provision that in case of the arrest of the accused, the arrestee's names should be displayed in the police control room but same provision is continued, but with some modification. Here, of course, it is stated here. That is, Section 37B is introduced. What does it speak about? It has fixed the responsibility to a police official of the rank of ASI. He has to supervise things. There shall be one designated police officer in every district and at every police station, not below the rank of ASI, who shall be responsible for maintaining and giving information to the public about the details of the arrested person. For clear visibility, the names, addresses, and charges against arrested persons can now be prominently displayed through digital means also. Arrest and warrant. The summons can be issued now through electronic means. That is there. We'll come to that shortly. Then arrest and warrant. Then in case of arrest and warrant, of course, the duty cast upon the police officer to give the necessary details to the arrested person who is executing the warrant. Arrest of a private person now. Then if a private person, if he arrests an accused, then he should produce the accused before the police within 6 hours. Then 43 speaks about the power to put handcuffs. This is much spoken about now. But here are certain safeguards given herein. Those should be taken into consideration. Not in all cases. Especially here the accused is an habitual offender, or is known to have committed the offences repeatedly, or there is a chance of his escape from the custody, or once he has already escaped, or is involved in terrorist act, a drug or related crime, illegal possession of arms or ammunition, or murder, rape, such a serious offences. Of course, handcuffs can be put to the accused. Immediate seizure of weapons. Section 50 provides for the immediate seizure of offensive weapons after the arrest is made. Appointment of public prosecutor before the Delhi High Court. That is the provision introduced in Section 18(1) for Delhi only. Another thing which is of practical use to the lower courts is that of the power given to the district magistrate to make some alternative arrangement in case of absence of people. In most of the cases where the cases are being delayed due to the absence of the appointment of PPs, lack of the PPs, some cases are being delayed now. Now that is properly met with. That the district magistrate is now empowered with the power to make alternative arrangements. And a police officer not below the rank of inspector of police can be appointed, give assistance. But the same should be intimated to the state government within 40 days. That notice should be given to state government within 14 days from the date of such appointment. Post of district director of prosecutions. Here, a new post is created to make the prosecution agency more stronger. Appointment of special executive magistrate. Special executive magistrate, this is under Section 15. The state government is now authorized to appoint a special executive magistrate. Any police officer not below the rank of superintendent of police are equivalent in addition to any executive magistrate. Executive magistrates here either to only revenue officials. Who is the executive magistrate, MRO or Tahsildar, or district magistrate is district collector. Now, of course, a superintendent of police can also be appointed as a special executive magistrate in certain cases. Then general neutrality for the purpose of service of summons. 62 and 64 of CRPC, you know pretty well. 62 is personal service. 64. What does it speak about? It says that it can be served upon a elder male member. Now that is removed now. Any male member. Some adult male member is now taken out, and in its place some adult male member is taken. That means even a woman, it can be served now. But it's proclaimed offender. The proclaimed offender. Earlier, a person could have been declared as proclaimed offender only after under few sections. Now is more elongated now. Then maximum utilization of technology First thing is summons in electronic mode. Summons can be issued in electronic mode. Communication devices, production before the court on Section 94 BNSS. The court can direct the production of such communication devices before the court under Section 94. Summons to produce documents and other things, including communication devices. Technological assistance during search and seizure. Search and seizure that should be recorded through audio video means. That is stated under Section 105 of BNSS. Such videographing can as well be done through mobile phone also now. Mobile phone. Recording of search and seizure through audio video electronic means Section 105. I already referred this Section 530, the trial and proceedings to be held in electronic mode. See friends, what a wonderful change brought into. That means that can be done through electronic mode. We have already adapted the same. Nowadays, we are conducting trials through electronic mode because of the corona, and we're more used to that. In corona, certain new things are known to us. We are adapting the same, we are implementing the same, we're continuing the same. And this is also now brought into in CRPC. Next, under Section 265 and 266, which deal with the evidence of prosecution for defense, the examination of witness is allowed to be done through audio video electronic means at the designated place to be notified by the state government. Then electronic mode, all these things. Examination of accused through video conferences. That is there. Section 316. And now signature of the accused can also be obtained. What is the mode within 72 hours? How to obtain it is stated here. The judgment to pronounce it, and that should be communicated to the accused. If the accused is in it is in prison or he is not produced to the court, so this can be done through electronic means. And of course, I already stated here the lodging of FIR 173, electronic mode that can be lodged. But what is required then? Signature should be obtained within 3 days. 173, one speaks about the same. The forward in the final report of the court, that is already we covered it, once 193. Forwarding the final report, 193. Electronic mode. Furnishing of copies, electronic mode. Then giving information to the victim, electronic mode. Then supplying of copies to the accused, 230 and 231, through electronic mode, is already recognized in the several judgments of the Supreme Court. You must have seen now. That means copies can as well be supplied to the accused through electronic mode to CD that can be given. Charge sheet copy can also be given. Then furnishing information to victim about progress in investigation, that is already covered now. This can be conveyed through electronic mode. Then another thing is service of conditional order passed 152 by district magistrate for removal of nuisance. That can be communicated through electronic mode on 153. Bail to under trials. Section 479. A sympathetic view has been taken towards first-time offenders who are now eligible to be released on bail. That is on a bond executed by them before the court. If such an accused has undergone detention for a period extending up to 1/3 of the maximum period of imprisonment prescribed for that offense, then quick disposal of case properties, 497. You will read 497. 497 of what? It has introduced several new things. It introduced the quick disposal of case properties even during the investigation. That means on preparation of a statement of the property by the court, within 15 days after such property has been photographed, videographed, and such statement, photographs and videographs shall be used as evidence in any inquiry, trial, or other proceedings. The court shall then, within 30 days after the statement has been prepared, order the disposal, destruction, and confiscation or delivery of such property. Of course, this is to be the further studied then, because how some practicalities are to be seen. Somewhat this property are destructed, what is the corpus may not be remaining, and what is to be done, and some guidelines are to be given. To wait and see for the judgments from the constitutional courts from time to time on this aspect. But of course, this is a laudable change here. The curbing delays in trials, power to postpone or adjourn proceedings. Here, see friends, adjournments are very much limited. That is completion of the trial within a particular period that is given here. To curtail delays resulting from frequent adjournments, Section 346 establishes a framework, that means a time limit, wherein the court, after considering objections from the opposing party, may grant not more than 2 adjournments when circumstances are genuinely beyond the control of the litigant. For that, the reasons are to be recorded in writing, and this provision aims to streamline legal proceedings, fostering efficiency while maintaining fairness and accountability in judicial process. This is 346, power to postpone or adjourn proceedings. Then curbing delays in getting prosecution sanction. This is the aspect where we have to pay much attention now. Prosecution sanctions are being delayed now. So that time, for that time limit is given now. To curb delay in getting prosecution sanction to prosecute public servants, time frame of 120 days is fixed. You have to see 218 speaks about the same. Then time prescribed for furnishing copies to accused. The first is, even for this, some delay is occurring now. Even for furnishing copies, what's happening now, there can be that can simply complied with, but in some courts there is still delay for all these things. Now the period time limit is fixed for 14 days from the date of production or appearance of the accused. In case of voluminous documents, what's to be done? Electronic means. A CD can be given. Electronic means. Or his email, for his email, the copy can be sent. In case of sessions cases, the copies of the statements and documents, sessions cases are issued otherwise than police report. That means upon a complaint. Then the copies of the statements and documents will be furnished through electronic means under Section 231, 230 and 231. 230, just like 207, 208. Previously 207, 208. Now 230 and 231. Curbing delays in committals of sessions cases, PRCs. Already covered it. 90 days period is given. From the date the cognizance is taken, it should be committed to the sessions court within 90 days from the date the cognizance is taken. The period can be extended to 180 days, but the reasons to be recorded in writing. Avoidance of delays by way of pendency of discharge petition. Pendency discharge petition already covered it. 60 days period. We have covered it. Then accused right to be had before taking cognizance. Private company, that is already covered. 223 already covered here. Avoidance of unnecessary arrests. This is very important. 349 safeguards the rights of citizens and restricts the need for arrest of persons. The magistrates, the first class, are empowered under this provision to direct any individual to provide specimens and samples without necessitating their arrest. See provision 349, power of magistrate to order persons to give specific signatures and handwriting or voice samples. Then some more changes. Identification and attachment of property of proclaimed person. Section 86. 107, attachment for future or restoration of property. 86, identification of property of proclaimed offender. Then another important thing is the giving the custody to the district magistrate. Who is district magistrate then? District magistrate is a district collector. He is now directed to maintain and manage the properties. This is a far-reaching change. Section 180. Of course, this, of course, you can find in other special enactments like Deposits Act and other acts. You can find this. The dismagistrate has got such a responsibility to perform. Now, this is introduced here in BNSS also. Section 118, management of property seized or forfeited under this chapter. The court may appoint the district magistrate of the area where the property is situated or any other officer that may be nominated by the district magistrate to perform the functions of administrator of such property. The administrator appointed in subsection 1 shall receive and manage the property in relation to which the order has been made under subsection 1 of section 117 or under section 120 in such manner and subject to such conditions as it is central government. Forfeiture of property in certain cases 120. Fine in lieu of forfeiture. Certain transfers to be null and void 122. Procedure in respect of letter of request, the application of this 124. 176(3), we already covered it. The preliminary investigation is required to be done. That is 173(3). That is also covered. And the protection to public servants, that aspect we already covered. That is a 174 as well as 223. And then 172. Persons bound to conform to the lawful directions of the police officer. This is important. In the newly inserted 172, the power of police to detain or remove any person resisting, refusing, disregarding, etc., to conform to any direction of a police officer is introduced, which warrants production of such person before the magistrate, and in petty cases, release of such person within 24 hours after the occasion is passed. 330, timeline of 30 days has been introduced. Challenge genuineness of any document. So, genuineness of any document, of course, several years are taken for giving decision on the admissibility of certain documents or upon the relevancy of certain documents. This should be covered now. For that, of course, this section is introduced. Then the experts are exempted to be called before the court unless the report of such expert is already there in CRPC, that is here once again added. No formal proof of certain document is already there in CRPC. Then to make criminal proceedings more efficient, Section 336 provides that where any document or report prepared by a public servant, expert or officer is used as evidence, the court shall secure the presence of successor in office of such, already stated, just we cover it earlier. Then quick disposal of medical report, that is already there, we already covered. Another important change brought into is that of Section 208. What is 208? Offense committed outside India, fugitives. Suppose when an offense is committed outside India by a citizen of India, whether on the high seas or elsewhere, or by a person not being such citizen, any ship or aircraft registered in India, he may be dealt with in the of such offense as if it had been committed at any place within India at which he may be found or where the offense is registered in India, provided that not destroying anything in any of the preceding sections of this chapter, no such offense shall be inquired into or tried in India except with the previous sanction of the central government. Friends, already stated, metropolitan setup is totally taken out. Assistant Session Judge is no more there. So these are all the important changes brought into, and of course some more changes are there. But the time is too, of course I have already taken 1 hour extra from you, and therefore I want to conclude my session here. Thank you very much.
Good evening, sir.
Thank you, sir. Thank you.
Sir, good evening,
Sir,
sir.
with your
Thank you, sir.
permission, can we take few questions?
Yes.
Sir, good evening, sir.
Good evening.
Sir, introduction of mercy petition provisions in this Bharatiya Sanhita, is it going to impact curative petitions, sir?
What is it, madam? What is it?
Sir, new CRPC has got the provisions of mercy petitions, no, sir?
Yes.
So these provisions which are included in this new law, are they going to have an adverse impact on the constitutional provisions connected to mercy, or the curative petition Supreme Court would be entertaining?
Madam, we have to wait and see about the interpretation of certain sections by the constitutional courts from time to time. We cannot express such opinion at the threshold now. To wait and see how certain provisions will be interpreted by the constitutional courts.
Okay, sir. Okay, sir.
So many provisions are there, but as I said, certain provisions may be challenged also. And how the constitutional courts will react, we have to wait and see.
Okay, sir. Thank you, sir.
Thank you, madam.
Hello, sir.
Hello.
Sir,
Very
I am
excellent presentation, sir. My question is, so judicial, this police custody, you said 15 days. Earlier, initial period continuously 15 days. Now, according to you, total police custody, whether interrupted or continuously 15 days only?
Only, yes.
Only a difference is initial period only. Now, interrupted in between part wise, they can take police custody.
As brother, previously,
yes, sir.
Previously, of course, that means it's existing law. We know that the police custody should be sought within first 15 days only. Of course, there are certain things. Suppose if a recruit is subsequently arrested, for him, of course, the fresh period starts from the date of his arrest. That is there. But the existing law, as per the existing law, the police custody should be sought within first 15 days only. But now, the police are given some beneficial thing. That means if they fail to seek police custody within 15 days, even then they can seek police custody within 40 days or 60 days. For which the investigation is required to be completed within 60 days and 90 days respectively, provided the accused is not on bail, or even if he is granted bail, his bail is cancelled.
Okay, thank you, sir. Thank you, sir.
Sir, Metropolitan Magistrate Court system has been done away with, no, sir? So now,
Yes,
in
madam.
that place, will the sessions courts prevail over even in metropolitan cities?
Madam, this administrative justice comes under the concurrent list. That means both state government as well as central government have got right to make certain amendments. But to wait and see, because some of the friends, they have made certain discussions with me. They expressed the opinion that some state governments are trying to introduce metropolitan setup also by way of amendments, because it comes under concurrent list. So far, the act goes, metropolitan setup is totally taken out. And this the other important post, that is assistant session judge, is also not here in BNSS. For that, of course, the chief judicial magistrate, up to 7 years, the only thing is chief judicial magistrate is given that power. Now, metropolitan assistant session judge, that is a senior civil judge, can act as assistant session judge on the criminal side. We all know that is not here in BNSS, and metropolitan setup is also totally taken out. But some states may introduce. That is what I feel is some states may introduce by way of amendments that may be brought into, because that is a concurrent list. It comes under concurrent list.
Okay, sir. Sir, do you find any difference with reference to summary trials in the new law?
Summary trials, of course, madam, I have shown it. Most of the upper values, so many upper values are increased now. So many offences are included now for summary trials.
Sir, authenticity of electronic evidence, sir.
As
Sir, authenticity of electronic evidence, sir, in prosecution.
authenticity of electronic evidence, for that, of course, BSA has also made certain improvements. BSA, Bharatiya Sakshya Adhiniyam. BSA has now repealed, is going to repeal Indian Evidence Act. That speaks about that electronic evidence. There are some more provisions are introduced therein. In secondary evidence also, you will see sections 58. 58, some more clauses are introduced there. And also there in BSA, it is stated that, that electronic evidence is now primary evidence. And BSA was Bharatiya Sakshya Adhiniyam. Sakshya Adhiniyam is replacing Indian Evidence Act. So there, of course, certain new provisions are introduced. So we have to read all the three enactments at one time: BNS, BNSS, and BSA also. But so far as this act is concerned, some radical changes are brought into to make utmost utilization of electronic means, technology.
Thank you, sir.
Thank you, sir. Dr. Shri Krishna ma'am has asked a question. She is asking, sir, can you please provide information on changes made with respect to procedure relating to persons of unsound mind?
There are already provisions CRPC, madam.
She's asking if there are any changes made.
The same provisions continue now. The same provisions continue. And so unsound mind, of course, what is open is the magistrate should refer such person to medical hospital by invoking the provisions under the Medical Health Act. A report should be called for from the superintendent of the medical hospital, and till he is under that infirmity, the trial should not proceed with. All those things are already there in the act.
Okay, thank you, sir.
My question is that my question is
1 minute, madam.
I hope that I hope all the judicial officers who are present should be given training for the upgraded version of this IPC, CRPC, and etc., sir.
Exactly.
Because yes, because they have been working since long, and at a time at a stretch they are not able to. Many people are not able to understand this, because you are conducting classes to us like this, seminars and sessions, and you are giving us a very clear picture. Whereas the judiciary officers, there is 100% necessity to give training to them in this aspect, sir. What do you say, sir?
I completely agree with you, because ignorance of juris is not excused. We are well aware of that maxim. One cannot claim any excuse that he doesn't know law, because once an enactment is made by the parliament, it is deemed that everybody knows law. Everybody knows law. Even a common man is expected to know law, because he cannot take any excuse. But unfortunately, most of the people dealing with law every day, they are not aware of some of the legal provisions.
Exactly, sir.
And that too, BNSS, of course, they are very much scared of BNS. But I do not know, because hilariously, I will tell you about one joke. One of my friends recently said.
True, sir. You are 100% true, sir.
That he said that what he opined is that instead of changing the sections, the government could have as well changed the nomenclature, the name itself. But of course, it is just a joke. I just cutting a joke. What he opined is that he is using to so many projects, because he has already by-hearted so many sections, and so he is referring so many sections. It is very difficult for him to read the sections again and again. And the government ought not have changed the acts all of a sudden. Yes. What he said is, because we were more used to 302, instead of that we had to now say 103 BNS. But madam, what you correctly said, our job is a perpetual studentship. Students, we are still students. Everybody of us is a student. Every advocate is a student. Every judge is a student. We are bound to read law every day. When you amendment is brought in, or when new enactment is made, or a judgment law has come, I referred in the very beginning itself. There is a change being brought into because society needed it. Society expected certain things. Law should live to the expectation of society. That's why the amendments are brought into. That too, recently, these Chief Justice of India also expressed a lot of satisfaction about these enactments. But Madam, what you correctly stated is judicial training should be inevitable, but that is not being given now. The judicial, police officers are given extensive training, and some of people have also paid much attention in learning, but unfortunately, judicial officers not being tried, and some people, some judicial officers may not be under the impression that it will be implemented soon. So that ignorance should be removed. Then
always, sir, what I observe, this is my 27th year of my practice as an advocate in the High Court of AP, sir. But here, what the judges feel sitting in front of an advocate, they feel that just now you are telling we are always students. An advocate is a continuous student, a judge is a student, but my experience tells me that a judge will never accept this as a student, because though he knows or doesn't know, he pretends to know everything. Whatever we are shouting in front of them, whatever we want to bring, we are so, pressurized to bring the point before them, they don't like to accept, sir, because of this. So I feel that training, imparting training to these judicial officers is more important than these changes to be implemented immediately, sir.
I totally agree with you, madam. But madam, the presumption is that judge knows no law. Whereas that presumption doesn't apply to advocate. So judge should give patient hearing to an advocate. Suppose if some fine judgments have come in, that is because of the finest arguments submitted by the advocates. The advocates practically they guide the judges. Advocate is an advisor to the court, is an officer of the court. So every advocate will give much appraisal to the court. It will educate the court. The court should give patient hearing to the advocates, and the court should learn from advocates. That's what I feel.
Thank you, sir.
Sir, good evening, sir. My question is to section 176(3) of this BNSS.
Yes,
sir, basically the primary evidences and secondary evidences are divided, but there is a norm that the primary evidences are generally such as oral, the statements that are given by the people who are called as witnesses. But sir, in one way or another,
no, friend, the primary evidence and secondary evidence for document evidences. Because for oral evidence, direct evidence, the oral evidence should always be direct evidence. But hearsay evidence is admissible under certain circumstances. There is exceptions are there. Res gesia is exception 6, and so also section 32. There are exceptions under 32. So they're all exceptions to the rule that oral evidence should always be a direct evidence. Hearsay evidence is not admissible. But of course, the dying declaration it is nothing but a hearsay evidence. Res gesia is also hearsay evidence. They're all exceptions. So far as the document evidence is concerned, it should be primary evidence or document evidence.
Yes, sir. Sir, forensic reports are from long ago considered as secondary evidences, sir. From this BNSS under section 176, there is a mandatory provision to make forensic report for imprisonment for up to 7 years. Why these kind of forensic report are considered as primary evidence?
No, friend, this is not forensic report, friend. This forensic evidence means in Andhra and Tamil, in Telangana states, is already followed now. Forensics, that means we are calling for forensic. The investigating officer, once he registers an FIR in connection with some heinous offences, then he will call for the forensics. That means forensic experts will enter into the scene. They will collect the forensic material.
Yes, sir.
That is insisted here. 1763. What is cruise team. We call them as cruise team in Telangana and Hyderabad. Of course, in some other places in Telangana and Andhra, what we do, the police officers are doing, they are immediately sending message to the cruise team. That means dog squads, that's sniffer dogs. Sniffer dogs are brought into. Then forensic experts, they visit, they collect the blood samples and control earth and the blood stained earth. All these things they collect, fingerprints. That is made mandatory now. 1763, now it has become mandatory. For some states, they are not having this facility. So for that also, it is suggested now. Those states, they should borrow from other states.
Yes, sir.
Suppose neighboring states do not have such a facility. They can borrow from states like Telangana and Andhra, and of course Karnataka and Tamil Nadu and such states.
Yes, sir. As I have seen in court, oral evidences or such kind of statements have strong impact. As I have seen, if there is a forensic evidence that is contradictory to the oral statement made by such kind of witnesses, then the oral statement have got an uphand in those kind of circumstances, sir. As I have
Brother, expect evidence is something like resistance to the court only.
Yes, sir.
Much is dependent upon the direct evidence. Suppose an expert evidence is inconsistent with the direct evidence, which prevails. That is clarified by the Supreme Court from time to time.
Yes,
handling expert, suppose a doctor's evidence, medical evidence, it is inconsistent with the direct evidence, which is given much importance then. So that is there. Expert evidence is not absolute. Suppose DNA is different.
Yes, sir.
Of course, 112 of Indian Evidence Act, of course, there is the conclusive proof. Then originally, of course, the courts they did not allow a DNA report to be considered. You can see some judgments of the Supreme Court from time to time. They said that it's a conclusive proof. DNA evidence cannot be introduced. DNA experts, DNA opinion cannot be considered at all. But of course, seeing the change, because the DNA is now 90% accurate now. So they have changed the opinion now. So also the courts are changing opinion from time to time because law is bound to change. What I said, we are Krishna as judgment, the observation is also there.
Yes, sir.
Here, previously, what happened in 313 examination, suppose the accused keeps mum, adverse opinion cannot be taken against him. Suppose it doesn't give any statement. Then the court cannot take any adverse view against him. But now the law has changed now. What the Supreme Court said, under certain circumstances where the burden of proof lies in the accused, 103 and 106 of the Indian Evidence Act. If the accused keeps mum, he fails to explain the circumstances, then a different view can be taken now. So law is changing, brother, from time to time.
Okay, sir. Thank you, sir. Thank you so much.
Thank you, sir. Sir, Goyalji, do you have any question to ask?
Sir,
wait,
good evening, sir.
Nikhilji, please. He has raised the hand from a long time. Goyalji.
Okay, I am Gaddam Nikhil Kumar, sir, Department of Law from Central University of Karnataka.
Oh, okay.
సార్ నా క్వశ్చన్ ఏంటి అంటే ఇప్పుడు మల్టిపుల్ చార్జెస్ అయినప్పుడు బెయిల్ డినైల్ అవుతుంది సార్ BNSS లో మరి అది ఫండమెంటల్ రైట్ అనేది వైలేట్ అవ్వదా?
నో బెయిల్ డినైల్ ఎక్కడ చెప్పలేదు, BNSS చెప్పలేదు. స్పెషల్ ఎనాక్ట్మెంట్స్ లో ఉన్నాయి. మీకు బెయిల్ డినైల్ అంటే మీకు BNSS లో ఇప్పుడు నోవేర్ స్టేటెడ్ హియర్ ద బెయిల్ షుడ్ బి రిజెక్టెడ్. Nowhere said because it is discussed in the court. Facts and circumstances of the case should be taken into consideration. Denial of bail epudu vastundi meeku 37 of the NDPS stringent provisions and also under UAP Act 43D.
Okay, sir.
43D UAP Act and special enactments. Those are very, very stringent, very strict. Under those circumstances, bail may not be granted. But of course, IPC, so far as IPC is concerned, there are judgments from time to time that the rule is bail, but not jail.
Yes.
But of course, but the certain guidelines given by the Supreme Court from time to time, including recent judgment in the Muhammad Asfaq judgment,
Yes, sir.
Now, Anish Kumar's judgment, less than for offenses for punishment less than 7 years. What is to be done? So,
Yes,
41(1)(2)(d), that's such a checklist. B2, 41(1)(b)(2), 41 1B2 checklist should be given by the investigating officer in case the investigating officer proceeds to arrest the accused.
Sir, with your permission, one last question. Jilani, sir.
Okay, Jilani.
Sir, my question is now, what do you say, sir, with the investigation officer now he has to produce electronic record. Will there be a tough time for the defense advocate to defend now the police, and even otherwise also police cannot tamper under section 27 that he got the knife or some material object and replace it and get it. Now it will be tough time for both the defense as well as for the prosecution. One thing, and another doubt is, suppose when this police officer is recording through electronic media, it may be possible that that some other informant or complainant might have recorded it in some other day, not on the day on which they have visited, or on the days on which the occurrence might have occurred, and they might have produced it before the court. Will there be any such type of possibility or any possibility, sir?
Brother, strictly speaking, even now that is being there. Even
yes,
now,
sir, that is there.
In POCSO cases, so of course the recording of video recordings are being placed now. Victim statement is being video recorded now. How the defense is cross-examining, you know pretty well. Then of course section 27 of Indian Evidence Act, that is not at all changing now. Even BSA, also, a confession made before the police officer is not admissible in evidence now, except when the confession leads to discovery. Same provision continued now in BSA also. BSA also, there is not changed. These are the fundamental things, rudimentary aspects, and that cannot be changed now. So what happens then? You may put questions to the investigating officer about his method of recording, and you will get some favorable answers also.
Sir. Okay, sir. Thank you.
It doesn't give any special right to the investigating agency. So, but technology can be utilized now. What is stated is, instead of going in the conservative manner, because we didn't have technology previously, now we are provided with technology. You can make best use of technology. That is stated in BNSS.
Now, if the investigation is done properly, there will be a fit case for conviction.
Always, brother. Always. If a proper investigation is done, always there is a chance of conviction. But of course, the fundamental aspect of criminal jurisprudence, the burden of proof is beyond reasonable doubt. The accused is presumed innocent until the contrary is proved, until the guilt is established. So therefore, it is for the prosecution to prove beyond reasonable doubt.
Thank you, sir.
Sir, my sincere request to you, sir, is next time for such kind of sessions, you please prepare some PPT so that the students also can easily understand the main differences between the old sections and the new ones, which were.
If I'm given more time, madam,
yeah,
I would have been a little bit slow. In fact, I had some case law and some analytical discussion also. I wanted to do some discussion with all of you. But time is
చాలా బాగా ఎక్స్ప్లెయిన్ చేశారు సార్. బట్ ఏంటంటే ఇప్పుడు మేమంతా పర్వాలేదు కానీ పిల్లలు ఉన్నారు కదండి, స్టూడెంట్స్, స్కాలర్స్, వీళ్ళందరికీ కొంచెం ఇంకా ఇంపాక్ట్ బాగుంటుంది టీచింగ్. మీ బాగా లెక్చర్ ఇంకా వాళ్ళకి ఇంపాక్ట్ గా ఉంటుందని నేను.
In Hyderabad, of course, I'm giving physical sessions, madam. Some bar association, they are arranging some lectures. Rangareddy bar, recently Rangareddy and of course Karimnagar bar, they arranged some more lectures.
Very nice, sir.
You can have physical hearing. What I always want physical hearing, so that I can have optical communication with all of you. That will be better served. These webinars and all these things, these we are used to only during Corona period, and then we are continuing now. But I sincerely feel that it is very difficult to convey certain things through the webinars, and instead of that, it is always better if some physical sitting is there, and the speaker has got some optical communication with the audience.
Exactly. more than 350 participants were there today. It was a very good.
Yes, madam, your participation is good. Thank you very much. Thank you.
We will be happy if you can conduct some long sessions, sir, like 3 to 4 hours, or even if it is in a half-day session. That will be very much helpful to us.
Yes,
Sure, sir. We will try our best, sir.
Thank you. Because this being something, if it is a new act, a student can learn from the beginning. Now it is something already somebody has read it, somebody cooking and in between coming, and somebody is making further preparation on that. So it is difficult to.
Yes, brother, you could have seen my anxiety from the very beginning. I was running because I was anxious to cover more and more subject within time constraints, because time is passing on. I wanted to cover more and more. How that could be? Practically, I was running. Otherwise, I would have been a little bit slow.
But even then, you covered a lot, sir. Yes, sir. It was good,
But
sir.
I'm very thankful to all of you to have listened to the lecture by coping up with the speed also. I'm very much thankful to all of you.
Thank you,
so
sir.
much, sir. I'm
We are
student.
thankful to you, sir. You
Ma'am,
made
could you
sincere
please send
efforts.
the
You tried
feedback
to cover
form?
the whole document that you had prepared for us. Thank you so much, sir. Every section you tried to make us understand. Thank you so much for your sincere efforts, sir. We are really grateful that you accepted our invitation and covered this. I also would like to thank our dean, sir, who initiated this idea of a webinar so that we can have a little bit understanding of the new laws that have been come up. Dr. Basuraj Kubukadi, sir, Dean of School of Legal Jurisprudence Studies. And I also would like to thank the trustee of Vignenesha Pratishthan Trust. Thank you so much, sir. And today's resource person, Harekrishna Bhupathi, sir. Sir, we are really, really grateful that you took such long session and tried to cover everything for us. Thank you so much, sir, for your time.
Thank you, madam. Thank you to your university. Thank you to the dean, Basaraj Garu, and thanks to each one of them who watched this session. Thanks a lot. May God bless you.
So much.
Dear
Thank
Thank you, much
participants, thank you
obliged
so
for your
much
most
for your
valuable time.
patience.
This session was really insightful. Thank you. Thanks a lot.
Thank you so much, sir.
Thank you so much, sir.
We also thank
Thank you so
all the
much, sir.
participants who patiently
Thank you
listened
so
till
much,
the
sir.
end, and their interest to learn new aspects, without which we couldn't have organized this kind of successful session. Thank you all the participants for understanding and cooperating with us from the beginning.
Thank you, sir. Thank you for this wonderful session.
Thank you, sir.
Dear participants, the feedback form has been shared in the chat box. Please fill it. Thank you so much.
Okay, ma'am. I fill it. Can I exit, ma'am?
Sure, ma'am.
Okay, ma'am. Thank you.
Ma'am, I also filled, but the certificate, how long it will take? Yesterday it came immediately.
Actually, there is a daily limit of sending mails from our side because we are sending it to various participants. More than 300 participants have patiently listened and they have registered, filled the feedback form. So it takes time. Don't worry about the certificate. If you have attended, we have your attendance in the Google Meet. Even after the completion of the webinar, we will cross-check and we will provide you the certificate. It won't be a problem. Don't worry.
Sure. Thank you.
Thank you.
We are ending this session. If anyone has not filled their feedback, please fill it. We will end it in 5 minutes. Thank you.
Madam, I did not receive certificate yesterday also and today also, madam. What should I do?
Sir, please put a message to 1 second. Sir, can you see a number on what chat box in the chat box?
Yes, sir. Yes, sir, I can see.
Hello.
Yes, sir, I can see the number.
Please put a message in the WhatsApp.
Okay, sir, I'll do it.
Yes.
Thank you, sir.